Hi, and welcome to today's Berkeley Center for Law and Technology Advanced Life Sciences Institute presentation, Assessing Patent Protections Afforded Under the Safe Harbor Provision. My name is Allison Schmidt. I'm the Director of the Life Sciences Law and Policy Center here at BCLT. I am absolutely delighted to have three experts here with us today to explore this very important topic that seems to become more and more prominent year by year. And so with that, I'm going to go ahead and turn things over to our presenters.
Hi there, welcome. My name is Joe Loy. I am a partner at Kirkland and Ellis in the New York office. I have a wide-ranging federal practice focused primarily on patents and trade secret litigation, both in district court as well as on appeal, and have extensive experience in some of the issues that we'll be talking about today related to the safe harbor provision of the Hatch-Waxman Act. And I'll turn it over to Tasha now.
Hi, my name is Tasha Gerasimow, and I am a partner in the Chicago office of Kirkland and Ellis. I came to the law by way of a scientific training and background. I have a master's degree in organic chemistry and a PhD in chemical biology and worked in industry for a little bit before turning over to the legal side of things. And since then, my practice has primarily been in the life sciences space, and I enjoy discussing these types of issues and working with clients and other thought leaders on the issues that they present. I look forward to discussing it today with Joe and Jessica, who I'd like to turn this over to.
Hi everyone, my name is Jessica Lamb. I'm Senior IP Counsel at Novartis. So I handle all patent related issues for our commercial products focusing on the cardiovascular, renal, and metabolic franchise. And before joining Novartis, I was an IP litigation associate at Kirkland, the New York office, and following a clerkship at the Federal Circuit, Latham in their DC office. So thank you so much to Joe and Tasha for inviting me here, and Allison for having all of us speak today. Right, if we can go to the agenda slide. So our goal here is to provide an overview of the safe harbor provision and discuss the topics shown here on the slides. Safe harbor, under the normal infringement framework, any unauthorized making, using, or selling, offering to sell, importing of a patented invention without authorization constitutes infringement. And there is a limited exception under the safe harbor provision where you can use certain patented inventions when developing FDA-regulated products. But the boundaries are not always super clear, so that's what we're going to talk through today. Next slide, please. So it's an affirmative defense to a claim of infringement. It can be presented at district court or in the International Trade Commission proceedings relating to infringement of product and process patents. Essentially, you would be saying, the act that they are accusing us of doing as infringement is not actually infringement because it falls under the safe harbor provision of the Hatch-Waxman Act. It's a factual issue that requires discovery. So what was the use that's being accused? What was the purpose of that use? Who was doing the use, etc. And let's take a look at the statutory provision setting forth that exception to infringement. So next slide, please. So under 35 U.S.C. section 271E1, it shall not be an act of infringement to make, use, offer to sell, or sell within the United States or import into the United States a patented invention, ... solely for uses reasonably related to the development and submission of information under a federal law which regulates the manufacture, use, or sale of drugs or veterinary biological products. So what that means, next slide please, is that there is no infringement and safe harbor applies if two conditions are met. The invention at issue is a patented invention under the statute, and the allegedly infringing activity is reasonably related to the development and submission of information for FDA approval, for instance. And that, of course, raises questions of what exactly is a patented invention under the statute and what activities count as being reasonably related. And before we dive into those questions, I think it helps to understand the broader statutory framework and history. So we'll talk a bit about that on the next slide. Next slide, thank you. So this provision, the safe harbor provision, was introduced in 1984 as part of the Hatch-Waxman Act. The purpose of this provision was to correct an unintended distortion, in the Supreme Court's words, in the effective patent term of certain products due to the FDA approval process. Like I said earlier, normally it is an act of infringement to make, use, sell, offer for sale, or import a patented invention without approval. And prior to the Hatch-Waxman Act and the safe harbor provision, there was no exception even for uses relating to research, development, or testing required for FDA approval. And so what that meant is if company A wanted to start developing a drug, but company B had patents covering the active ingredient or the sequence at issue, company A wouldn't be able to start that research and development testing necessary for FDA approval until after the patent expiration. So counting in the time that it would take to do that testing, all of that research, to put together the submission, to have the FDA review and approve that submission, company B would then get an additional period of exclusivity if they had a drug covered by those patents, even though those patents were expired. So Congress created this safe harbor exception to address this issue. Next slide, please. And the Supreme Court in the Merck v. Integra case explained that the safe harbor provision makes clear that it provides a wide berth for the use of patented drugs in activities related to FDA approval. Of course, the practical application of this provision is not always straightforward. The two key phrases that have been subject to significant debate in litigation and in court opinions is, as I mentioned before, what is a patented invention under the Act and what constitutes solely for uses reasonably related to FDA approval. So let's talk about that first question. What constitutes a patented invention in the context of safe harbor? Next slide, please. So does it cover only pharmaceutical drugs, or does it cover any product subject to FDA approval, such as medical devices, food and color additives, etc.? So next slide, please. Thank you. So in the Eli Lilly v. Medtronic case, the Supreme Court held that a patented invention under the statute not only includes human drug products, but also any medical device, food additives, or color additives, so those things that are also subject to FDA regulation. They left open, however, the question of whether or not the safe harbor provision applies to research tools. So the equipment or testing methods or models that may themselves be patented, but are technically not themselves subject to FDA approval. So I'm going to turn this over to Joe now to discuss whether research tools can be protected by safe harbor.
The question of whether research tools can be protected is, as many questions in the law, not as easily answered as one might hope. First, we'd ask ourselves, what are research tools before we even answer the question whether or not they are protected. And the Federal Circuit in the Integra Life Sciences versus Merck case did answer this question. The opinion was authored by Judge Newman, who herself is a PhD chemist. And interestingly, as she was citing the various examples that may be research tools, including laboratory equipment, cell lines, antibodies, animal models, cloning tools, etc., she referred to the National Institute of Health's guidelines for the definition of what research tools might be. And in doing so, I think is not meant to be an exclusive list, but rather it's intended to be inclusive of the various tools that scientists would use in the laboratory to conduct research. So in fact, are research tools protected? Well, the answer is sometimes, and the answer is sometimes not. In this Perveris case, which was one of the key Federal Circuit cases from 2008, the patent owner brought an action against a competitor alleging infringement of a patent directed toward a system, which was an apparatus for characterizing aerosol sprays that are commonly used in various drug delivery systems. And in that case, the court was focused on whether or not the aerosol itself, the patented aerosol, was a FDA pre-market approval, or whether it was used for itself to be FDA pre-market approval. And in fact, it found that it was not. And for that reason, there was no escape from an infringement allegation. And the court also looked not only as to whether or not these aerosols were used as a pre-market approval process, but whether or not the party who was using the aerosol was in fact subject to the exceptions or the perversions that Jessica mentioned earlier that Hatch-Waxman Act was meant to correct by not allowing an extension of the patent term to exceed that which was granted by Congress through the process of only being able to begin the FDA approval process at the point at which the patent expired. So here the question is, no, the research tool is not going to be protected under safe harbor. Here's some other examples where courts have concluded that the research tools themselves are not excluded from protection. And in the PSN Illinois case, we have Abbott's use of a patented invention related to molecular cloning not being protected. In this case, you have, again, a similar circumstance where the molecular cloning that was being used as a research tool was itself not the item that was being sought to be FDA approved, but rather it was used in the process of attempting to develop drug candidates for an S1P receptor that itself may have been separately protected, but the molecular cloning tool itself was not. Allele Biotechnology is another case out of the Southern District of California, in which the plaintiff there alleged that the claims of the patent encompassed an neon green product, which was a fluorescent protein used as a biological tag in genetic engineering work. And the plaintiff further went on to allege that the defendants had used the neon gene to research, develop, and test their COVID-19 products. And here again, the COVID-19 vaccines that were being examined were not, those would have been the FDA approved product, but the neon gene that was being used to assess whether or not those COVID-19 products should be commercialized were not the subject of FDA pre-market approval themselves. And so again, under that same theory, those research tools were not protected under safe harbor and were subject to infringement allegations. Regenexx Bio is another case, this case out of the District of Delaware, where Judge Andrews at this point is looking at some of the precedent. This is a later in time case. And so he concluded that the Regenexx Bio product there was a patented product that itself, again, was not subject to the FDA pre-market approval process, and therefore he fell in line with this prior precedent that held, in the context of this motion to dismiss, that Sarepta's use of the patented cultural hosts to make a gene therapy product would not be protected by safe harbor. And as we stated at the beginning here, that the answer is not always that there is never an exception to infringement under safe harbor based on a research tool. This is a good example, the Teva Pharma case, v. Sandoz, out of the Southern District of New York, where Judge Forrest is grappling with some of these questions of whether or not research tools, almost de facto or as a bright line rule, cannot be included. And this is an example where she distinguishes the prior precedent, including some of the cases we just discussed, where the facts are going to be very determinative as to whether or not there can be exclusion. Here, because the methods were the patented technique, there was really a focus on what is the patented technique at issue in this case. She was able to distinguish the Proveris line of case law as being very different from the application at issue here. And so this research tool, because it was in the process of seeking FDA approval and was one of the directly patented features that was relevant to the FDA approval process, it was excluded and found safe harbor here. There's also, reading the case, there's also a distinction between who the infringer is. So here there was the third-party infringers who are not necessarily the entities themselves seeking FDA approval versus the alleged infringer being the entity in the process of seeking the approval. And so that distinction can matter as to whether or not the research tools will be protected. As with many issues in the law, the takeaway is it really will matter. So the facts are going to be determinative. of the outcome, and it will be important to get the guidance of counsel as you're making these decisions to determine whether or not you, in fact, would have safe harbor applications. So then the question is, in the statute, what is an activity that's reasonably related to the federal regulatory activity? Obviously, the FDA is the administrative body that governs the approval process for drugs and new medical devices. This question was examined in a case that made its way all the way up to the Supreme Court on cert. It's Edwards Life Sciences versus Merrill Life Sciences. In this case, if you go to the next slide, you had a Merrill Life Sciences who was attending a CTC conference in San Francisco, and they had a few transcatheter heart valves that they brought into the United States with the intent of showing those devices potentially to researchers that may be using the devices in the US in order to assist with the process of seeking FDA approval. It turns out there were some technical issues where the devices, they were branded as MyVal, were not actually operable, and according to submissions to the district court, the devices were never shown to any of the potential researchers. However, the devices were imported into the US, and therefore, for that reason, although they were not necessarily used or offered for sale, the importation provision of the infringement statute was invoked. And the question the court asked itself is, was Merrill's importation of those transcatheter heart valve devices into the US exempt from infringement because they were reasonably related to the submission of an FDA approval process? And the court ultimately concluded, if you go to the next slide, that the answer was yes. Right, so other reasonable related uses here, 271E1 covers, as you can see from some of these cases, submission of data to foreign regulatory agencies. And in this instance, the facts are very specific in the NeoRx case or prescription case that the data was also being submitted to the FDA. So that fact seemed to be an important one, that the data was related to an FDA submission, not just a foreign regulatory agent. Another potential reasonably related use is using the patented product to develop alternative FDA approval processes. In Amgen, you have an example there. In Bristol Myers Squibb, you have a use of an FDA-generated data to prepare patent applications. So you may, in this instance, you had some alleged infringing acts where the data was then itself being used to file for US patent applications, and those uses were reasonably related to the infringing act. And then finally, experimentation on drugs that are not ultimately the subject of FDA approval. If the intent is to submit an FDA approval process, that can also be, even if you don't go through the final application and you don't submit anything, that can be exempt under the safe harbor. Lastly, the question often comes up if you're facing a motion to dismiss, for instance, can safe harbor apply as a matter of law? Often courts are reluctant to determine these issues on a motion to dismiss or as a matter of law. And the reason is, I think as Jessica stated, that application of the safe harbor defense is a affirmative defense to an allegation of an infringement, as opposed to one that may otherwise be amenable to just not being reasonably pled. And so these matters often are factually intensive and will involve some degree of development of the record before they can be pursued on summary judgment or at trial. In this instance, in Blue Allele, you have a motion to dismiss for failure to state a claim, but the court ultimately denied that motion to dismiss because some of the accused activities were not reasonably related to FDA approval. And moreover, they concluded that these tools would be research tools outside of the patented invention, in line with some of the prior cases as well. With that, I'll turn it over to Tasha.
Great, thanks so much. So now we're going to shift gears slightly and talk about some recent developments in the regulatory space and focusing a little bit on this American Clinical Laboratory Association versus the US FDA case that came out of Texas in March of 2025. So a little background about this case. The FDA had issued a final rule announcing its intent to treat all laboratory-developed test services as medical devices and to regulate them under the FDA-Cosmetic Act, the FDA statutory provisions that are giving them the authority to regulate them. So under this rule, safe harbor protections could likely extend to laboratory-developed test services. So what are laboratory-developed tests, LTDs? They're in-house diagnostic tests that are intended for clinical use and are designed, manufactured, and used within a single laboratory that meets certain certification requirements under the Clinical Laboratory Improvement Amendments of 1988. And they meet regulatory requirements to perform these high complexity testing and types of analyses. These tests provide information about a patient's health, and it provides information that's useful to diagnose, monitor, or determine treatment for various diseases and conditions. And they can be used to measure or detect a wide variety of substances or analytes in human fluids, including proteins, glucose levels, cholesterol, DNA, etc. So here are some examples. There's common examples of LTDs are genetic screening and testing kits. Diagnostic testing for rare diseases are examples here. Other tests involve hereditary cancer testing and screening. There's also LTDs for viral and infectious disease tests. Many of us are likely aware of the COVID tests and respiratory virus panels. They're also used for newborn screening to identify metabolic diseases or endocrine diseases as well. Okay, so turning back to this case, the American Clinical Labs case, what happened there was that the court ended up vacating the FDA's final rule, holding that it exceeded the FDA's statutory jurisdiction and basically saying that these types of tests are services. They are not medical devices. And so a little bit about that case in the decision from the court said that the final rule had contemplated expanding the FDA's jurisdiction to cover these laboratory-developed test services as medical devices. And the court said that that expansion is foreclosed by the text, the structure, and the history of the two acts, specifically the FDCA and the CLIA. Congress had considered the unique regulatory issues that were raised by these types of tests, and they addressed them through comprehensive amendments in the CLIA, and specifically not the FDCA. And it's clear if you look at the FDCA, that text talks about a division of labor where it grants the FDA authority over devices and defines in terms what those devices cover and not services. And then at the end of the decision, the court goes on to say that the FDA's text made clear that the devices within its purview do not extend to these types of services. And it's asserted jurisdiction over these LDTs as devices under the FDCA defies bedrock principles of statutory interpretation, common sense, and long-standing industry praise. So they're pretty stern in explaining why this would be inappropriate. And so pursuant to the court's holding, LDTs do not fall under the FDA's authority and therefore would not be subject to regulation as medical devices. So just a few takeaways here. Regulatory classification disputes may impact whether safe harbor protection applies. Products that are not subject to a required FDCA approval process is not a patent and invention. You'll want to consider whether activity is always reasonably related, like Joe and Jessica were talking about earlier, to fall into the safe harbor. And it needs to be reasonably related to the development or submission of information for federal regulatory approval. And as this case illustrated, uses that fall outside of FDA oversight are going to require some additional legal analysis to see if the safe harbor is applicable here. These, again, can be fact-specific circumstances that may still support a claim for the safe harbor defense, but it really is highly dependent on the facts and the regulatory context and intended use that surrounds the particular issue. Okay, going back to what is and what is not covered, what about basic research? The Merck case, dating back to 2005, made clear that basic scientific research performed without an intent to develop a particular drug or reasonable belief that a particular compound would cause a particular desired effect is not reasonably related. It's too early. It's just basic research, and you're not going to find cover in the safe harbor provision if you're just too early in this process, just at the stage of basic research. Section 271E1 also does not cover manufacturing patented products in the US for shipment to a foreign regulatory authority. So that's not going to be a situation where the use is reasonably related to FDA approval here in the United States. Similarly, use of a product for foreign clinical trials where there's no indication that those results would ever come back to the FDA, that's also not going to be reasonably related. So the safe harbor provision would not apply in that context either. So takeaways, a company's subjective intent or alleged commercial purposes are irrelevant when determining whether the safe harbor applies. And it's always important to tie the activity in some way back to FDA approval of the drug or the device, or even supplemental approval or label modifications. You really need to find that tied to the US to FDA regulatory approval to maintain the safe harbor defense. Another question that commonly comes up in these cases is the timing of the research. Does that matter? And again, drawing back to what we were just talking about with basic research, yeah, it can matter. Courts have found that activities are reasonably related to federal regulatory activities, regardless of a particular phase of the research, and that can even date back to preclinical studies. But as we talked about, things that are too early, like basic research, may not be reasonably related. A relevant case here for those who are interested would be this Isis Farms case. This came out of the Southern District of California in 2014. The court held that Santaris' use of patented methods related to antisense technology to identify targets or to screen for activity were not protected. Again, this is along the lines of too early. We're just screening for potential targets here, potential activity. It just comes a little bit too untied to FDA regulatory approval. And this was the case even though Santaris had a reasonable basis for believing that one of these molecules could affect the selected targets and could maybe one day be developed into a drug. But they had no evidence to show that it actually was the case and it would occur through a particular process sufficient enough to justify a basis going forward to tie it to regulatory approval. Okay, so just switching gears slightly now, we wanted to talk about some remedies when the safe harbor does not apply to research tools. You know, what can you do about this? What are some remedies that you can be seeking or at least thinking about and maybe thinking creatively about in some instances? So an injunction barring continued use of a research tool is questionable. Recently, the Federal Circuit reversed in part and remanded in part a case that was holding that an injunction prohibiting a new clinical trial was overbroad as a matter of law, and that the trial court had abused its discretion in enjoining the competitor from offering open label extensions to current clinical trial participants. The court vacated and remanded the injunction to the extent it barred the defendant from seeking FDA approval for new indications. So this is this Jazz versus Avadel case that was recently before the Fed Circuit in May of 2025. So injunctions are a big ask and they're going to be scrutinized, I would say, is one of the takeaways here, but something to be thinking about when you're looking at potential remedies in this space. Lost profits and royalties on the sale of commercial products are also going to be challenging to obtain. Relevant cases to review if you're interested in pursuing those theories are listed here. The Panduit case that came out of the Sixth Circuit, an old case here. And you also want to look at Johns Hopkins University versus CellPro, a more recent case. And then just to float it, there is some Hatch-Waxman law that's related to the concept of experimental use, so not safe harbor, a different application here. But it suggests under that case that parties may seek destruction of data arising from infringement and withdrawal of related data submitted to the FDA. This is a very old case. This came out of a case from Pfizer back in the early 80s. But it's interesting to think about if there is a potential remedy there to seek the destruction of certain data that arises from these infringing acts. Again, this is an old case, different context, but if people are looking to identify potential remedies, this might be an area that people might want to revisit at some point. And with that, I'll turn it over.
All right, so we're going to talk a bit about some additional guidance in instances where there's stockpiling or post-FDA approval activities and who is covered or not covered by the safe harbor protection. So with respect to stockpiling, so if there is stockpiling of the patented invention for preparation of the commercial launch of the product in anticipation of FDA approval, that is not protected by safe harbor. And that makes sense, right? Because market launch after FDA approval is not a use related to FDA approval. And critically, to go back to what Tasha was talking about with respect to damages, stockpiling may result in damages being awarded to the patent owner, even if there is no actual commercial sale of the product. And this is from the Amgen v. Hospira case that's shown on the slide here, where the jury found that some, but not all, of Hospira's drug batches that they manufactured were protected by safe harbor. There were documents and deposition testimony that came out during discovery suggesting and showing that not all of the batches that Hospira manufactured were used for, or in fact needed for, FDA approval, and that Hospira made batches that were not required by the FDA, and some of the batches were in fact intended for commercial inventory. And for the use of the patented invention that was not protected by safe harbor, the jury awarded Amgen a damages award of $70 million. And the Federal Circuit affirmed that decision. Next slide, please. But of course, if the stockpiling has some connection to, or can be tied back to, the FDA approval process, it may be protected by safe harbor. And in the NeoRx Corp v. Immunomedics case, the Federal Circuit found that the manufacturing of an additional commercial scale lot beyond the 3 lots that was required by the FDA approval process still fell within safe harbor, because Immunomedics manufactured that extra lot in case the FDA required additional information as part of the approval process, and also that the FDA was aware of the plan to scale up production. So those 2 facts were something that the court looked at in determining whether or not this additional manufacture of the commercial scale lot fell within safe harbor. And in the Amgen case, the manufacture of commercial batches that are likely to generate useful information, so information that can be submitted to FDA for approval, it may be protected even if the results are not submitted to or used by the FDA in the approval process. And ultimately, the requirement that the use be reasonably related to FDA approval does not mean that the use has to be necessary for FDA approval. Next slide, please. So what about post-FDA approval activities? Are those protected by the safe harbor provision? Next slide, please. And it depends, as with most of the things that we've discussed, on the specific facts at hand. So routine activities conducted after approval for routine reporting to FDA is not protected by the safe harbor provision. In the Clausen v. Biogen case, the court there found that there was no safe harbor protection for post-approval activities related to vaccination studies. So even though the results of those studies were, and the adverse events were reported to FDA as part of a routine matter, it was not being submitted for FDA approval and therefore fell outside of the scope of the safe harbor provision. And the Momenta v. Teva case reinforces that as well, that there is no safe harbor for routine quality control testing that is done post-approval, because that is not connected to the FDA approval process. Because safe harbor ultimately is not intended to protect activities relating to ongoing commercial manufacture and sale. It's supposed to protect activities relating to FDA regulatory approval. But certain non-routine activities conducted after the initial FDA approval can be protected by safe harbor. So activities relating to pediatric studies or label changes would fall under the safe harbor protection when those activities are related to FDA approval. So in the Clausen v. Elan Pharmaceuticals case, there the activities being accused of infringement related to a submission for a supplemental NDA to revise the product label, and that activity was deemed to be protected by safe harbor. And because the label dictates the use of the pharmaceutical product, any updates to the label has to go through FDA approval process. So even though there was already an initial approval for one indication, or the original indication rather, of the pharmaceutical product, updating the label to include a new indication required submission of information necessary for FDA to review and approve that new indication. And finally, question may come up with respect to who is covered by the safe harbor provision. So we've discussed so far cases that focus on the entity seeking FDA approval. And in some instances, right, if the activity meets the statutory requirements, then that entity would be protected by safe harbor protection. But there's can be a question with respect to third parties. So the parties that are not seeking FDA approval, but are still involved either because they're supplying the active ingredient, for example, or the research tools being used by the entity that is seeking approval. And that, of course, is a fact-specific question. With respect to third parties that are supplying the active ingredient, coverage for them may depend on the specific timing. So if the supplier is providing the active pharmaceutical ingredient pre-approval, that is something where the Federal Circuit has determined that safe harbor protects the third parties there, because that use of the patented invention was directly related to the FDA approval process. However, if the third-party API supplier is providing the commercial API after approval, then that third party may be liable for induced infringement. And this is from the SmithKline v. Geneva Pharmaceuticals case, where the court found that the supplier who was going to be manufacturing and selling generic products after FDA approval could in fact be sued for infringement by the patent owner. And finally, with respect to research tool suppliers, those entities may not be covered by the safe harbor provision. So going back to the case that Joe was discussing, the Federal Circuit in the Proveris case found that there was no safe harbor protection for a third party supplying research tools, where that third party was making and selling products that could be used by a generic applicant to conduct tests to calibrate the drug delivery devices for their product. Because the drug delivery devices did not need FDA approval, it wasn't ultimately a patented invention under safe harbor provision, and that research tool did not meet the requirement for safe harbor. And then in the Teva v. Sandoz case that Joe was discussing, there the district court found that safe harbor protection applied to the use of research tools where the entity at issue was the entity seeking FDA approval, which is sort of the distinguishing fact from the Proveris case, where the defendant there was not the one seeking FDA approval for the use of for the patented invention. So the takeaway here, as with the other points that have been discussed, is that the protection for third-party entities may depend on timing, and of course, the entities, the scope of their involvement in the submission is also a fact there. I'll hand this back over to Joe to discuss.
I'll take that one. So let me run through the summary. So these are the key takeaways from everything we've talked about today, really distilled down into these next two slides. So what is the safe harbor provision? It's a defense to infringement proceeding, the district court, and also the ITC. Under the safe harbor provision, a patent and invention is broad. It can cover drugs, biologics, medical devices, food additives, colorants, maybe research tools, depends at the time and the situation there. But we do know that basic research without specific FDA purpose is not going to be protected. And again, the research must be reasonably related to the development and submission of information to the FDA. The information can be used for other purposes without losing protection, for example, marketing, foreign filings. Actual submissions not required. Validation batches can be covered. And research tools and stockpiling may be protected if, again, it's connected and reasonably related to FDA submissions for review and approval. Limited post-approval activities can also be protected even if the drug is currently being marketed. Third-party entities, again, it's kind of a case-specific analysis here, but there may be protection, again, under the safe harbor, always, again, depending on the circumstances here, focusing on the timing, the activities that these parties are engaged in.
Right, so we have a few best practices tips on this slide here. So it can be critical to determine whether any patented technology that is not itself subject to FDA approval will be used and for example, research tools, et cetera? And if so, it's important to assess the risk associated with that use and potential mitigation strategies we have discussed with respect to the cases. As part of that assessment, you can also consider what actions are at issue, who is performing that action, are there any timing issues, and if third parties are involved, look into whether indemnification is possible, either under the current agreement or to seek another indemnification agreement with the third-party suppliers. And because safe harbor protection is very fact-specific, it helps to have detailed records establishing that defense. So keeping detailed records that, for example, tie the manufacturer of a commercial lot to quality control testing for FDA approval can be quite helpful, because if you're relying on broad, unsupported allegations that, oh, everything that we were doing is tied to the FDA approval process without specifics, that is something that can be insufficient for asserting this defense. And this goes back to the Hospira case that we talked about earlier, where the litigation position of the defendant, that safe harbor attached to all of the batches that they made, did not match the contemporaneous documents showing that they made additional batches beyond what was required for FDA approval or beyond what they were planning to submit for FDA approval, and deposition testimony where the witnesses admitted that they weren't sure why those additional batches were made.
Finally, as a practical matter, because many infringement cases include allegations of willfulness, and a finding of willfulness can lead to serious implications, including damages, it is often good advice to seek the opinion of counsel. And the opinion of counsel can often come from someone who is familiar with the FDA approval process and or also familiar with the research and development processes that go into applications for drug approvals. So those can be particularly helpful defenses in the event that you find yourself with an infringement allegation, to establish good faith belief that what you were doing, as well documented by those records you kept, was in fact, at least from a scienter perspective, was in fact within the safe harbor, even if ultimately the safe harbor does not apply. And then finally, if we just turn to the last slide here, we're happy to take any questions. Both Tasha and I are practicing in this area regularly, and you're free to email either of us with any questions, and we'd be happy to continue the discussion.
This has been a really wonderful program. We are so lucky to have benefited from all of your expertise and really helpful comments. Thank you so much to the audience for joining us, and we look forward to seeing you as part of our next program.